Thank you for joining us. I'm Dan Sutherland. I head up our professional services team here at Fox Williams, and I'm joined today by Ed Livingstone, who's a legal director in our professional services team as well. We've advised many firms on setting up business in London, and something that we increasingly find is that US firms, US law firms in particular, when they're choosing the form of legal vehicle that they're going to use for their London office, they are turning to a US LLP, typically formed under the laws of Delaware or New York or various other jurisdictions. This has become an increasingly popular route for a number of reasons, and we think is a very topical question given that the potential for the extension of certain taxes to English LLPs is now in prospect. So, Ed, can you tell us a little bit about what the key differences are between a US and a UK LLP?
Yeah, absolutely. They sound very similar, and obviously they both will end with the suffix LLP, but they're actually very different. Firstly, we need to say that there are sort of 50 jurisdictions under which a US LLP can be formed, and they have quite significant differences between them. An English LLP, or UK LLP, as you call it, is incorporated at Companies House. It's a corporate entity with its own separate legal personality, and is sort of deliberately, when it was first introduced about 25 years ago, was designed to resemble much more like a company than a sort of traditional general partnership. LLPs elsewhere, outside of the UK, including in the US, are sort of a bit more of a partnership style model and less corporate. Sometimes they won't have separate legal personality. Sometimes you can choose to have legal personality or just be a body of persons in the way that a general partnership is. This has a number of potential issues that we'll come on to from a sort of tax and regulatory and potentially a legal perspective, but there are increasingly advantages to opting for a US LLP.
Yeah, I mean, I think what I'm seeing in terms of the advantages that are most pertinent in people's minds when they're looking to establish US LLP, the one that's sort of most recently been introduced is the idea that they can use cash-based accounting, which is different from the traditional accruals basis accounting that UK LLPs and companies are obliged to use. And the benefit for that cash basis accounting is, well, there's two really. One is if it's a US firm, they're probably using cash basis accounting in the US, and so it's a consistency of accounting basis across the UK and US. And the second reason is that cash basis accounting is generally considered to be a more favourable basis for firms because it recognises revenue later. And so you recognise the revenue later, you pay tax on the revenue later. And so it's a not insignificant difference. Now, there are complexities around this for which you need specialist tax advice, but cash-basis accounting is certainly one of the things that has led to firms coming to us to talk about this. And indeed for those who are currently UK LPs considering the transition. Some of the other advantages I think that we have spoken about with clients surround filing obligations and disclosure obligations. So as you mentioned, the UK LLP is something that is established at Companies House, and it has all the normal disclosure obligations that in the UK we understand is a necessity when you have a limited liability vehicle, including the identities of the partners or members as they're properly called, audited accounts, and disclosure of various other facts about the entity. As a US LLP, those disclosures are simply not needed, and there's no need for audited accounts, so they lose that audit cost and the privacy that comes with not having the audited accounts filed. There is some disclosure required at Companies House for some overseas LLPs if they hold leases. If they hold a long lease, that will need to be disclosed around the ownership and ultimate beneficial ownership, but it's quite a limited level of disclosure. So that's a key advantage. The other key advantage is also they will avoid the salaried member rules. And for those who don't know about the salaried member rules, those are rules that HMRC imposed in 2014, which essentially required certain kinds of partner who are paid on a primarily fixed basis to pay tax as though they're an employee, in particular employers' national insurance, which is a significant additional cost. That simply doesn't apply to the US LLPs, so you simply don't have that requirement, and that removes a huge headache and degree of uncertainty about the proper tax treatment of partners. So those are all pretty significant advantages. There's one advantage which I guess could be an advantage or a disadvantage depending on which side of the fence you sit, and that is worker rights. So it's been pretty clearly established by the court that worker rights apply to UK LLP members. It's much less clear whether those worker rights apply to the partners in a general partnership or partners in a US LLP. Those worker rights, they are not quite the same as true employment rights, but they do, from a firm's perspective, give partners rights that can, in some situations, be unwelcome.
Yeah, absolutely. Things like the sort of pensions auto-enrolment potentially, but also there's whistleblowing, which was the Supreme Court case about 10 years ago, which established that English LLPs members would have worker rights, isn't there? And then I suppose on the tax side of things, you talked about the salaried members rules, and there's also the prospect of an additional tax being discussed in terms of English or UK LLPs, but we think that it may not potentially apply to US LLPs and non-UK LLPs.
Yeah, I mean, at the time we're speaking, the proposal by the Resolution Foundation is that it would be applied to UK LLPs only, so far as we can tell. How the government treats this remains to be seen, but it does open up the possibility of further divergence of the tax treatment of UK and US LLPs in favour of US LLPs.
Yeah, obviously this isn't to say that there are only advantages and no disadvantages. I suppose the issue that we often sometimes see with our clients who are non-UK LLPs is the kind of confusion it causes amongst banks, insurers, regulators, namely the SRA, in terms of they're not having a company's house presence, which can be easily checked and therefore used to verify who their members are or partners, who their persons of significant control are, and so on. So it tends to be a bit slower in terms of setting things up with banks and so on. There's also a potential, perhaps slightly academic issue, although it's not been tested in the courts, as to whether an English court would uphold the limited liability that is conferred by the US state jurisdictions legislation, which states that there is limited liability because they are very much like general partnerships in a lot of respects. So there isn't necessarily a separate legal personality, which is the defendant in the case. It would be essentially the body of individuals comprising the partnership, and so there may be questions as to how the limited liability would work in those circumstances. So that's obviously perhaps a slightly remote question, but still something to think about. I suppose there's also, if you're an existing firm in the UK operating via a UK LLP, there's the sort of cost and time and attention that's associated with getting from there to a US LLP, say New York or Delaware or whatever it may be, because there's no sort of strategy mechanism whereby you can just flip from one to the other in the way that there might be in terms of re-domiciling between US jurisdictions. So it has to be nothing less than a sort of wholesale transfer of the business and assets and all of the contractual relationships of the existing UK LLP that operates the London office, and transfer all of that wholesale to a newly formed US LLP, which is by no means an easy process. The new LLP is obviously going to need its own regulatory authorization that can't easily be transferred. It would have to be a fresh application to the SRA in the case of a law firm for authorization, which obviously could take up to 6 months or 9 or even 12, plus moving the office lease. You're going to need landlord consent for that, and that's not going to be forthcoming. Bank accounts transferring from UK to US LLP, insurance policies, and so on. So it's sort of all of the myriad contractual relationships it have to go across, and you have to deal with that, not to mention client relationships as well, which is sort of got its own difficulties, particularly for large firms where they have a lot of ongoing matters. So certainly Certainly, it's not a decision to be taken lightly, but I think I'd be right in saying a few of our clients are engaged in the process of converting or actively considering it, given the advantages that we discussed.
Yeah, absolutely. I mean, it's definitely a high effort process, but particularly if you're already established here in London, ultimately it's one that shouldn't disturb the normal running of the firm whilst it's ongoing, and so to that extent it can be something that is managed by a group of people with their advisors. And so I think we will see probably an increasing number of firms making this transition over time. I think primarily I would expect that to be amongst firms that are US in origin, because for UK firms it's unlikely that they would want any kind of US nexus that they don't already have, given that the US is also known as quite a litigious place. So nonetheless, though, we think this is an interesting area where there will be some activity. So yeah, thank you, Ed. And I hope that was an interesting professional services group bite-sized discussion. If you have any questions about the issues raised, then please do get in touch with Ed or myself. Thank you.